They offered him $3,000 for a pair of pants. He said no. $4,600. No. $12,000. No. Instead, he demanded $54 million, and the man demanding it was a judge. This is the case the whole country laughed at without knowing what it actually cost. The headline number hides the people inside it. Pearson was an administrative law judge representing himself. The Chungs were a South Korean immigrant family running a neighborhood dry cleaner. At distance, the case sounds absurd. Up close, it is about pride, language, money, and a small service dispute climbing the full escalation ladder of American litigation. Start with Pearson before the case became a punchline. He was an administrative law judge in Washington, D.C. During the dispute, he was also in divorce proceedings, had about $1,000 to $2,000 in the bank, and was collecting unemployment benefits. The record shows pressure but also conviction. He believed a real legal wrong had occurred. There was more context. In his divorce litigation, Pearson had already been sanctioned $12,000 for creating unnecessary litigation and making threats involving disbarment against his wife and her lawyer. That does not decide the pants case, but it sharpens the portrait. Pearson approached conflict through legal process, and he approached this dispute the same way. Follow the dates. On May 3, 2005, Pearson dropped off gray pants. On May 5th, he returned and was told they were not ready, but would be ready the next morning. On May 6th, he came back again. Still no pants. In an ordinary dispute, this is where a refund conversation begins. Here, it became the foundation for a statutory claim. On May 7th, the conflict hardened. The Chungs presented a charcoal gray pair of pants. Pearson refused them, insisting they were not his. Pearson's version: the cleaners lost his pants and tried to substitute another pair. The Chung's version: the pants they produced were his. The legal mountain sat on that factual question. Now, across the counter, Jin Chung, Sue Chung, and Ki Chung ran custom cleaners as a family business in Washington, D.C. They were immigrants from South Korea and did not speak fluent English. They had no national brand, claims department, or in-house counsel, just a shop now facing the case that became the $54 million pants lawsuit. Their argument was not simply, "we owe nothing." It was about scale. A service problem, even a real one, did not create unlimited liability. A customer could be compensated without turning store signs into blank checks. In their view, Pearson was trying to convert a routine retail dispute into a statutory jackpot. Two storefront signs moved to the center of the case. One read "Same-Day Service." Another read "Satisfaction Guaranteed." Pearson treated them as enforceable promises under the District of Columbia Consumer Protection Statute. The Chungs treated them as ordinary retail assurances, not an unconditional promise, letting every unhappy customer define satisfaction for himself. The escalation ladder matters because the case did not begin at $54 million. First came the dispute over whether the returned pants were Pearson's and whether he should be paid. Pearson demanded more than $1,000. The Chungs refused. Then came settlement offers: $3,000 rejected, $4,600 rejected, later $12,000 rejected. At each step, the money rose, and so did Pearson's insistence that this was about principle. Pearson then built a statutory theory. He first sought $67 million, then on May 30, 2007, reduced the demand to $54 million. The categories tell the story: attorney's fees, mental distress, weekend car rentals, and even a fund to help other consumers sue businesses. The logic became clear. Pearson said the signs meant what they said. Same-day service and satisfaction guaranteed were promises, and consumer law should have teeth. The Chungs answered that those words were not blank checks. Satisfaction could not mean one customer's unilateral power to impose catastrophic damages. The bench trial began on June 12, 2007, in the Superior Court of the District of Columbia. This was not a jury trial, despite how people remember it. Judge Judith Bartnoff would hear the evidence, interpret the statute, and decide the facts herself. Pearson appeared pro se. The Chungs appeared with counsel. The atmosphere was anything but ordinary. The courtroom drew a standing room only crowd. Reporters packed in. Spectators came to watch the famous $54 million pants case unfold. Outside, it was a national curiosity. Inside, it was still a trial about dates, receipts, signs in a window, and legal consequences for dissatisfaction. The human strain showed through. During his explanation of the dispute, Pearson broke down in tears, and the court took a short recess. That moment is easy to mock from the headline, but Pearson did not experience the case as satire. He experienced it as a genuine wrong that had consumed years of his life. The Chungs answered through attorney Christopher Manning, who represented them at trial and later on appealed pro bono. His point was direct. The signs were not unconditional promises, and Pearson's reading would make ordinary advertising dangerous. A family cleaner could not safely say "satisfaction guaranteed" if one customer could define satisfaction and multiply damages into the millions. The proof stayed concrete. The judge had the May 3 to May 7 timeline, the receipt, the returned garment dispute, photos of the signs, the settlement history, and Pearson's damages categories. From outside, it looked like a bizarre multi-million-dollar showdown. On the evidence table, it was still a tiny retail dispute wrapped in an ambitious theory. Because this was a bench trial, there was no jury box to absorb sympathy, irritation, or spectacle, no deliberation room, just one judge comparing what Pearson wanted the signs to mean with what the law and evidence supported. The case was not rejected by a laughing jury. It was decided by a judge issuing findings after trial. Pause and weigh the arguments as the court had to. Pearson's strongest point was textual and consumer-facing. Businesses should not post same-day service and satisfaction guaranteed if those words have no enforceable meaning when service fails. The Chung's strongest point was proportional and practical. Even if service failed, those signs were not a limitless warranty and could not justify damages millions of dollars beyond the garment's value. What is your ruling? Is this a consumer protection case with real principle behind it, or a claim that outran the facts beneath it? Comment your ruling before you scroll. One answer is coming. Here's what the court actually found. On June 25, 2007, Judge Judith Bartnoff ruled for the Chungs and awarded court costs to the defendants. She refused to let same-day service and satisfaction guaranteed carry the weight Pearson placed on them. The result was not that consumers have no rights. It was that this record did not support this theory, and certainly not these damages. The judgment did more than reject a headline number. It imposed consequences by awarding costs to the defendants. That matters because the court treated the Chungs as prevailing defendants entitled to recover at least some litigation expense after years of fighting over one pair of pants. The trial ended, but the litigation did not. On August 14, 2007, Pearson filed a notice of appeal. The case moved to the District of Columbia Court of Appeals. Oral argument took place on October 22, 2008, before a three-judge panel. Pearson again argued pro se. Christopher Manning again argued for the Chungs, defending the limit between ordinary advertising and unlimited liability. The appeal did not rescue the case. On December 18, 2008, the D.C. Court of Appeals rejected Pearson's appeal. On March 2, 2009, it denied rehearing en banc. In plain terms, the appellate court left the trial result standing. The pants claim had now failed at both available levels in the local court system. The aftermath landed unevenly. For the Chungs, winning did not mean normal life returned. On September 19, 2007, they announced they had closed and sold the dry cleaning shop involved in the dispute. Even a successful defense can be ruinous for a small family business when years of cost, stress, and publicity attach to one lawsuit. Pearson's aftermath was severe too. He later lost reappointment as an administrative law judge. Years after the pants litigation, the D.C. Board of Professional Responsibility imposed a 90-day suspension from legal practice, and the D.C. Court of Appeals upheld that suspension in June 2020. The pants case was not his only professional event, but it stayed attached to his public identity. The lasting lesson is that scale can become the case. A customer may have a legitimate complaint. A business may make promises that matter. But when a missing garment dispute passes rejected offers of $3,000, $4,600, and $12,000, then becomes a $67 million demand reduced to $54 million, escalation itself tells the court something about proportionality, credibility, and purpose. The court ruled. Did it get it right? Next time, the United States government sued a dinosaur skeleton and the dinosaur lost. Subscribe for that case where a fossil meets federal court.